into questions just so you don't have to completely wait till the end. So I'm going to share my screen. And we'll also be providing you a copy of this PowerPoint and the materials that we talk about, and I'll also make sure that you're aware of where to find certain materials that are available on the web. So I'll ask the question in the Zoom way. Is there anyone who cannot see the screen right now? No, okay. And I was going to do the slideshow, but it kind of gets tough to toggle back and forth. It might be a little wonky, but I'm going to give it a shot. And then if it becomes too cumbersome, I'm going to stop doing that. So essentially, this training talks about the grievance process and the appeals process. I'm going to touch lightly on the grievance process. It is pretty similar to customer services, and it's not been as much of a question as it has been with the appeals process. So I'm going to focus a little bit more on the appeals, but certainly if you have questions about that, let me know. So this talks about people's rights around the grievance and appeal process and how that affects folks who have Medicaid and folks who don't have Medicaid. And there's been some, well, they were significant a while ago, there were some significant changes in the Medicaid managed care rule. There's been a little bit of changes with the rules this past year about the process, so this is going to cover that too. I am a Medicaid history nerd. I'm not going to go through a lot of that with you, but basically there was a time prior to Medicaid managed care that people actually could have anything happen to their services, have any decisions made, and they didn't really have any say in what occurred with that. They couldn't question it, they couldn't challenge it. And when the Medicaid managed care rules came into play, what used to be called the Balanced Budget Act, there was a lot of enhancements for the rights of people who don't have a lot of money, who are dependent on the system for their care, to have a voice and to kind of question things. So that's kind of the history around where the appeals process came from. It's in the treatment world, I guess it's relatively new as a process, but the rule started in 1998 and it had to be implemented by 2000. So I guess we're a little bit older than we used to be. The purpose of the whole process is for people to have a way in which they can ask for and get a second opinion, ask for an appeal if there's something negative happening with their services, and file a grievance with anything else that they're dissatisfied with their services in. And general information around kind of the foundation for the system. People who file a grievance and appeal have to be free from discrimination or retaliation. The thing that I like about that is, and we'll talk about hearings down the road, but the judges who do the hearings take this very seriously and have a lot of respect for the people in the process. So it's been nice to see that it's just not something people write down on paper, they actually do it. The grievance and appeal process needs to support the spirit of resolving concerns and improving the quality of services. The goal is also to resolve concerns locally as much as possible. The spirit behind that is the folks that we serve are more empowered on a local level to resolve things than having to bring a third party, which is an administrative law judge, in the middle of it to resolve the process. They need to be informed of their rights and given reasonable assistance in filing appeals or grievances. Sorry, and basically the options are a second opinion, a grievance, which is always local. There's no federal level or state level process for that. Internal appeals for people who have Medicaid, local appeals for people who don't have Medicaid, the state process for hearings for people who have Medicaid, and the state process for what they don't call hearings for people who don't have Medicaid. We're not going to cover the family support subsidy appeals. That's very specific to CMH and the CMH code and the mental health code, so that doesn't apply to you. Folks have a right to a second opinion when they're denied eligibility for services or when they're denied inpatient. It has to be provided by the person who's at the same level, or at least, or higher than the person who made the original decision, and they have 30 days to ask for that. That's going to happen more on kind of the assessment process, not the intake process, and relevant to if they're found that they don't meet criteria for SUD services, or if they're found that they don't meet criteria for the most intense level. That's kind of the spirit of it. So for us, that would be detox or residential. If they're denied a service, the second opinion review needs to be done within 5 business days for them. And then the time frames are shorter as the level of service becomes more intense. So if it's a denial of detox or residential, it would need to be done within 72 hours for a review. And if it's an emergency, and that's a tougher one to think of with the SUD world, but if it is an emergency, it's within 24 hours. That's usually kind of a inpatient psych issue. It might be a detox issue, but I haven't seen that happen a lot in detox situations. And the second opinion process needs to be provided at no cost to the person. For most of us, we're a no-cost system anyhow, but that's just part of the rule. So I'm going to stop at that point and talk and check to see if we have any questions about the second opinion process.
Nothing is coming yet in the chat.
Okay, great. Grievances, like I said, I'll cover this a little bit, but a grievance is a person's ability to express when they're not happy with what's going on. And the best way to define it is what it's not. It's not something that would be handled by recipient rights, and it's not something that would be an appeal-related situation. And these are just examples of grievances. They're real-life ones that the customer services staff have received in the past. It is managed by whoever does customer services. Sorry, did somebody say something? No. Okay. Who can file a grievance are the same people who can file an appeal, the individual, the guardian, or the parent of a minor. Anybody else can call and complain. It's just not called a grievance. It's not tracked that way in the data. They can be filed verbally or in writing. It's only done on the local level. There's no time limit to file a grievance. They can request it whenever they want to, and they're handled by the customer services person at the local provider. I'm gonna, sorry.
CJ, I had a quick question.
Yeah.
For the right to a second opinion, should that be given to them in writing and then documented in the chart?
Yes. The fun part about that is and I'll get to this when I get to the forms, but the state provides certain forms that are expected and required to be used, and then they don't have forms for other things.
Right.
So we just, the regional body, there's a group of fair hearings officers, excuse me, who manage all this. And we've been looking at some of the new contract language and what's going on at the state with the appeals process. And we've created our own templates. We're actually just in the process of finalizing those.
Okay, great.
And we'll make sure that that gets included in the packet of resources for you all.
All right, thank you very much.
And a grievance needs to be resolved with a written response to somebody within 60 days. And then kind of the heart of the matter, why we're here, is the appeals process, which is a person's ability to ask for a review of a decision that's been made about their services or a request for services. So the appeal rights that everybody has, there's some variations between folks who have Medicaid and folks who don't have Medicaid. And there was a significant shift in that in October of 2017 in that fiscal year. The Medicaid managed care rule itself changed, so the state had to change what they do. So the federal law is the system that gives rights to folks who have Medicaid in the appeal system. States can, but aren't required to, give similar appeal rights to people who don't have Medicaid. The most significant change that has happened with the Medicaid appeals process is historically, if you had Medicaid and there was a negative action that was taken with your services, you could take that case right to the judge. You could skip, go. You could get out of jail for free. The Monopoly references. You could go right to the judge and have your case heard and have a decision made. With the change in the law, it requires that if you have Medicaid, you have to go through the internal local appeal process first before the judge would hear your case. And that was a significant shift that I think we're still trying to help individuals understand. There's still some challenges with that. Only a consumer or their guardian can file an appeal. And folks have a right to have what's called an authorized hearing representative, both at the local appeal and the hearing. And basically what that is it can be anybody they want. And that varies quite a bit. It can be a friend, it can be a family member, it can be an advocate. Sometimes it's an attorney. And they can identify that person in writing. It has to be in writing. That gives that person permission to have all the information about the appeal. That person becomes the main contact. But also the individual can still be present at the hearing, can still participate. It doesn't take away any of their ability to be present or be involved. It's essentially a part of the system that's set up so that if people feel intimidated by the system or don't feel empowered to have a voice, we've especially found this with people who've not had really good experiences with the criminal justice system and being in front of a judge. It gets a little intimidating, that they have somebody else to support them and have a voice for them so that their concerns can be heard. With the appeals process, folks have the right to ask for a copy of their record in order to prepare for an appeal. And the only caveat to this that's important is we have standards around if you're requesting a copy of your record for standard medical record reasons, there's a time frame that we can be held to that allows for us to pull things together and might be a little bit longer. If it's related to an appeal, the need to respond quickly is important to a request for a record, because sometimes if we stick to those timeframes, like the CMH would have 30 days, the appeal could have already happened and the person wouldn't have their information. So if it's not clear when they're requesting it, I do ask folks, or I have asked folks, when is your appeal? Like, how soon do you need this? When's the date? So that we can address that and respond to that quickly. So when do people get notice of their appeal rights? And this has changed a little bit. I learned today that you can't track changes and cross things out in PowerPoint without it being deleted completely. So that's why I made this super tiny, that one area, because there has been a recent change in the law around this. But folks with Medicaid have a right to appeal, which in turn means they need to be notified of their appeal rights when they are denied a service they ask for, or they don't get the amount or level of services they're asking for. It's still considered a denial. It's called a limited authorization. Or it takes, actually, this is the part that's changed. It takes longer than 14 days to provide a service. And it takes, The part that doesn't apply to this anymore is it takes longer than 14 days to answer a request for service. I have to change that real quick, but I can't while I'm doing the presentation. If they're already getting a service and that service is suspended, reduced, or terminated, or there's a denial of payment for services that aren't prior authorized. Okay. Folks have the right to request an expedited appeal, and basically, if they feel that there's a significant threat to their health or safety, they can request the appeal be expedited. I've not found this happen very often. I think in the entire time I've done fair hearings, and I've done those for more than 15 years. This comes up very rarely. It's probably come up maybe twice in my experience. But if they do request an expedited review, we have to review it to determine if it's necessary. And if we deny it, they have a right to file a grievance. The one caveat to this is if a consumer requests an expedited appeal, we have the ability to review it and determine if that's really necessary, medically necessary, or if it's warranted. If the treating provider makes a request for an expedited appeal, that expedition has to be granted. The assumption is the provider has a clinical expertise, and if they're requesting an expedited appeal, it's for a justifiable reason. We have to make a decision about whether we're going to expedite somebody's appeal within 2 days. We do try to call them rather than send something in writing because of the urgency of what they're requesting. And if we do approve an expedited appeal, it has to be completed no later than 72 hours. So again, when you think about the context of this is pretty urgent areas, things like detox. I'm not even sure that residential would necessarily qualify for this, but detox probably would. And if we are denying a person's right to an expedited review or their request for an expedited review, they have a right to file a grievance. And along with, and this will come up later, but along with the comment I just made about second appeal letters, there's been some there haven't been state resources about how to send letters like this for a grievance. So we also have those resources. We've created our own templates that we'll provide. Again, this happens very rarely. So you can always call if it comes up and you're not sure what to do. So decisions that give rights to grievances but not an appeal, these used to be appealable decisions and they're not anymore. The first one is if somebody asks for a service and it takes us more than 14 days to decide that, we can extend that to an additional 14 days and they're notified of their right to file a grievance. They used to have the right to file an appeal with us. Now they only have the right to file a grievance. Like I just said before, if there's a request for an expedited appeal that gets denied, if there's a delay in answering a request for an expedited appeal, we can extend that to a 14-day time frame, but they need to be able to file a grievance about that. And if there's a delay in a request for an appeal, we have time frames around when the local appeal needs to be done. If it takes us longer than that, they also have a right to file a grievance about that. So pretty much kind of the heart of this is anytime we're extending timeframes for things we're supposed to be doing in these 4 areas, folks have a right to request a grievance. For appeals, folks who have Medicaid have 60 days to request a local appeal. The day that we receive that local appeal, it has to be completed in full 30 days from the day that you've gotten the request. So that means the review and the decision is out in writing within 30 days. If the local appeal upholds the denial, that person has 120 days from that day to request a Medicaid fair hearing. The only timeframes that have an extra caveat to them are essentially services that somebody already has, where there's something negative that's going to happen with those services. So if services someone already has are going to be reduced, suspended, or terminated, folks have the right to request an appeal within 10 days. They still have the whole 60 days, but if they request an appeal within 10 days, within the first 10 days, they can request to continue those services, and those services need to continue until the appeal is completed. There is a component to the regulation, the law, that says they have to be informed that they may have to repay those services if the denial is upheld. Sometimes that depends on ability to pay, sometimes that depends on other things. It is kind of at the discretion of the entity involved to review that, but they do need to be informed about the risk of that. So basically, kind of the spirit of this is if the services I'm already receiving are being taken away, if I really feel strongly that they don't need to be, folks are probably pretty much going to act pretty quickly about requesting that appeal. And this kind of speaks to if it's important enough for them to believe that they still need those services and they request that within 10 days, the spirit of the law allows them to continue those services until the decision is heard. If you don't have Medicaid, folks who in the past, before the law changed in 2017, folks who didn't have Medicaid had pretty equitable rights around the appeal process as Medicaid did, and the state made some significant shifts to this. So the only time somebody without Medicaid has the right to appeal is if they're being denied an inpatient admission. For us, that would be detox or residential. If they're being denied services that they're requesting once they're denied a hospitalization, so pretty much kind of an initial request for services, and if their services are being suspended, reduced, or terminated that they're already receiving. So if you look at the difference between Medicaid and non-Medicaid, there's a pretty significant shift in the number of reasons a person without Medicaid can file an appeal. They can't file an appeal for initial request for any other service besides an urgent service. They can't file an appeal around any kind of basic denial of services during treatment planning, anything like that. And the timeframes are a little bit different for an expedited appeal review. It's between 72 hours for Medicaid and 3 business days for folks who don't have Medicaid. And they need to be informed of their right to file a local appeal with a decision. And again, expedited appeals don't happen very often, but folks who don't have Medicaid also have the right to that. Folks without Medicaid have 30 days to request a local appeal. Their local appeal, we actually have an extra 15 days to finish that. It has to be finished within 45 days of the request. And then their time frame for being able to go to the state for an appeal. So because it doesn't involve Medicaid, the fair hearings process before an administrative law judge only applies in Medicaid and with Medicaid regs. If you don't have Medicaid, what the state has set up is the contracts people at the state will review what they call an alternative dispute resolution. It's the state level review of a non-Medicaid request to take a look at the outcome of a local appeal. The tough thing for them is they only have 10 days to do that, versus a Medicaid consumer who has 120 days to go before the state level appeal. The state contract is silent on whether folks even have the right to continue their services. during a suspension, reduction, or termination for non-Medicaid. That's pretty much at the discretion of the entity that's reviewing the local appeal. And they're also silent on the right to appeal other denials outside of a second opinion. So whenever the contract is silent, basically our approach is we can't hold people to a requirement that doesn't exist. So it can be at the discretion of the entity that's reviewing the local appeal. And I'm going to stop there for just a second, see if there's any questions about Medicaid versus non-Medicaid appeal processes. Nope. All right. So providers' involvement in appeals. Providers can be involved in appeals by appealing on behalf of a consumer, which is separate from a consumer appeals process. And they can request an expedited appeal, which I said before is something that has to be honored. It can't be denied. They can also be, they have been in some situations, the authorized hearing representative on behalf of the consumer if the consumer asks them to. Sometimes that has been at the discretion of the provider though. So for example, and this happens more on the CMH world side of things than I've seen it happen on the SUD side of things. But sometimes a consumer will ask like their case manager to be their authorized hearing rep or their therapist or somebody close to them. And there have been times when it's at the discretion of the person being asked about whether they want to be the authorized hearing representative. And there have been times when that staff has talked to the supervisor and talked about whether that's kind of a, not a conflict of interest really, but really not their role, or it might affect their therapeutic relationship, or it might be a kind of outside of the scope of what that person is being provided by that staff, and they can decline to be the authorized hearing representative. I have had contractual providers be present as the authorized hearing representative more so than like a case manager or a therapist. And providers, the one thing that gets paid attention to this with the judge, however, and I think it's only happened twice, 2 or 3 times in the time that I've done hearings. One of the things that the judge or who's ever reviewing the appeal needs to be considered of or concerned with is whether the consumer, the individual, really wants that provider to be involved, or whether the provider is kind of inserting themselves. There was a situation where we discovered that when the appeal request came in, the provider actually essentially coerced the consumer into filing an appeal because the decision that was being made was affecting the provider's business and the provider's wanting to provide services, and they were concerned about maybe staff jobs or volume of referrals, and wanted the consumer to appeal the case so that they continue to be the provider. Most of the times when things kind of look fishy like that, you can kind of tell that something's quite not right. So we investigated a little bit, talked to the judge about it, and did find out that the consumer was being coerced to request an appeal. And that was addressed by the judge. We worked with the consumer to find out if they really want to file an appeal or not. They ended up not, but just kind of being considerate or careful of those situations and ensuring that it's really what the consumer wants is part of the process. So with that, we're going to move into providing notice of a person's right to appeal. We're going to cover what that needs to involve, what needs to be in a notice. And like I said a little bit earlier, we're also going to be sharing, as a follow-up to this, what resources the state gives with those forms, where to find them, and what resources that the state hasn't rolled out as kind of a statewide rollout, and what we've created and can make available to the rest of the system. So essentially, a person needs to get notice of a negative action, which is legally called an adverse benefit determination, which is really friendly language. And most times, this is going to be the community mental health system, the PHP, or the SUD ROS core provider. I've done a little bit of digging and tried to kind of figure out times where fee-for-service SUD providers would be in the position of providing notice. Really, the entity that gives notice is the one that's making the decision, making the service decision. And I'm open to hearing feedback, but so far what I've come to discern from that is fee-for-service SUD providers, most of the time, the decision they would make is to terminate services or to discharge somebody who hasn't completed services, and that they would be in the position of giving notice. We haven't had a lot of SUD-related appeals, and both the state, the Michigan Administrative Hearing System, also our Consumer Advisory Council, there's always the question of, or wondering, like, how come there's not the same level of SUD appeals as there are for CMH appeals? And part of my response to that has been, you know, there is the ability for, I mean, there's ability for CMH too, but in terms of making service level determinations, the individual can request a change in those services or can request a different level of care, and that sometimes they might want a level of care that's less than what's being recommended. A negative action really only has to do with, are you giving less or taking away? Giving somebody more than what they want isn't considered a negative action, and that person not wanting more than what you're wanting to give them wouldn't be considered a negative action. I'm not so sure they are totally on board with some of those theories, but they are paying attention to what's going on in the SUD world with appeals. And most of the appeals that we've had, there hasn't been a SUD level for hearing in quite a long time, but the actions that usually go to that level seem to be related to either termination of services or decisions that are made around Medicaid-assisted treatment and or methadone maintenance. If titration's happening, if reduction's happening, if people are being discharged from that system, that's where some of the appeals have been happening. One of the, and I'll talk about this a little bit later too, is one of the nice things about having appeals data, or one of the nice things about having appeals is the state takes a look at every appeal that occurs at the hearing level, at the ALJ level, administrative law judge level, and they also take that data. So one of the positives that's actually come out of this process, specifically related to methadone maintenance decisions, is they changed the Medicaid provider manual about the process around that because of how appeals were coming through. That actually made the process clearer and created some structure around that, so that there wasn't the need to kind of unnecessarily or excessively give notice around things like titration and things like shifts in meth doses, that methadone doses that were coming out of previous appeals. So as much as sometimes this seems to be kind of a task, kind of a big lift sometimes with the appeals process, there is some great things that come out of the data that actually help the system down the road. So folks need to be given written notice of these decisions whenever they're denied service and any of the decisions we discussed earlier. And essentially what I found too is the minute somebody gets a piece of paper that looks like it has legal writing on it, which these do, they think they have to do something. So we've tried to enhance some of our forms to say, if you're okay with what's happening, you don't have to do anything with this. Really, the only reason you have to take action is if you're not happy or you disagree with the decision that's being made. Some of the historical forms haven't been really great about clarifying that. And then people think that if they don't send something in, oftentimes kind of the biggest issue that's come up is, I got this piece of paper, I'm afraid you're gonna take away my Medicaid insurance if I don't fill it out, so that's the reason I filled it out. So really trying to help people understand what it's about has been part of the work of what we've been doing the last couple of years. So there are state forms that are required. We used to have our own forms, we created our own forms, and the state contract shifted last year and is asking us to use those forms. And this is the link where you can find them. I'm going to walk through them and just a bit down the road. Like I said before, they're not all the forms that we might need to use, so we'll have those available to you. But the state has been pretty clear that they're going to be paying attention to ensure that we're using the forms that they provided for us. And I'll talk a little bit about that in a sec. So in general, the information that has to be on these is the service the service involved, the date that the decision was made, the date that decision actually becomes effective, and if it's a denial decision that's not related to a suspension, reduction, or termination, those two dates are going to be the same. If it's a denial decision that's related to suspending, reducing, or terminating a service, that decision date and that effective date should have at least 10 days in between them. I have at times, when I was involved in the UN program and was actually sending these notices out, if I knew somebody was on vacation for the next week, there were times that I would extend that so they had the additional 10 days. You don't have to. The law only says that you have to make that start date and effective date 10 days. But I can say that there have been times that I've extended that when I knew that it was probably an important decision for that person, and they wouldn't have the full days to respond. Again, an internal decision for you all. The information also has to include their right to be provided at their request and free of charge. Any and all copies of documents, records that we use to make that decision. So any information that they ask for to say, how did you come to the decision that you sent me the notice on? And an explanation of what the decision is, why it's happening, and the legal citation behind that. The fun thing about the legal citation is the state has added some of that language, but it's not super thorough. I'll talk about that a little bit down the road about how we're going to approach that. But if that legal citation ever kind of trips you up, feel free to give me a call. I have a whole list of them about what would be applicable for different decisions. But again, we can talk about that down the road in just a sec. The notice also has to include the right to request an appeal, how to do that, what the process is, what an expedited appeal is and when they can ask for one, their rights to have their benefits continue, pending resolution of the appeal and how to ask for that when it's related to a suspension, reduction, or termination, the caveat that they maybe have to pay for those services if the final decision upholds the original decision. And if you don't have Medicaid, the non-Medicaid notices are similar, but much less intensive about just the action that you're taking, the reason, why you're doing it, and an explanation of the local appeal process. And there used to be some language, and I don't know if you all were familiar with this, but there used to be a time when we were giving people notices, the same format of notices that we do for negative actions when their services were being approved. This created a whole lot of confusion for people because the forms literally looked the same, that they were the same structure, unless you were really reading them and paying attention to what was on there. The form for your services have been approved looked the same in structure as the form that your services were being denied. We gave a lot of feedback to the state about that. It was causing a lot of confusion for people that we were serving, causing sometimes undue panic. So they changed the process and the rule so that there's a different way to inform them of their services being approved. It's no longer related to these appeal notices. They're not connected to the appeal notices at all. You can either give them a written description through the treatment planning process. So in the CMH world, we already, in our electronic health record, we already have a way where when you print out the plan of service, the authorization and how much services you're getting is already tied to that. It's already connected to that. Or you can send them an explanation of benefits. But you don't have to send them that form, any kind of notice form. So really, as long as you're giving them information from the treatment planning process about how much services they're getting, you'll meet that requirement.
CJ, we have a quick question, if that's okay. So if an SUD consumer has met their treatment goals and mutually agrees to terminate treatment, but there are still services authorized, do we have to send a notice of denial?
I know it's trombone day. Sorry, can you read that again?
Can you hear
Because
it?
I'm really
so
enjoying
sorry.
it. Yeah. Okay.
Sorry, everybody, you're getting serenaded.
No, I love it.
If an SUD consumer has met their treatment goals and mutually agrees to terminate treatment, but there are still services authorized, do we have to send a notice of denial?
Okay. So you would send a notice, but it would not have to be an advanced action notice. And unless you have it in writing, and I'm not sure how this works. We can talk about this a little bit. And because I know there's different types of electronic health records and there's a lot of variation in documentation. It's a little bit harder to kind of give a overarching response. But what we do is to ensure that, and the CMH side of things is to ensure that it's documented in the record that the person agrees or has signed off that they've achieved their goals and agree to the closure of their case. And at that point, you're kind of following the spirit of the law. And they still have, I mean, they can still come back and say, I want something else, or I changed my mind, and then that's kind of a different service decision. The key that I found is, as long as it's clear in the record that they're agreeing to this or they've signed off on this, if that's not clear, it becomes a little bit muddy about whether we should have given them a notice.
Thanks. That was the only question so far.
Okay, thanks. So I want to walk through the local appeal process itself because this is, at this point, this is a process that's delegated to each provider. And I'll talk about the state level fair hearings process in a sec. So this walks through kind of what the process needs to look like if somebody's requested a local appeal and how to do that internally. As I said before, with Medicaid, the whole process needs to be done within 30 days. If you don't have Medicaid, it needs to be done within 45 days. The review, and I'll talk a little bit about, so this presentation doesn't account for the world of COVID-19 and the pandemic and what's happened with virtual and remote. So I'm gonna kind of throw those caveats in as we're talking. But the review itself needs to include people from the agency who weren't involved in the previous decision, weren't subordinate to the person who made that decision, and essentially has the clinical expertise and the authority to make decisions. That all can be the same person. That all can be one person, that can be more than one person. But as long as there's an objective review of that decision that's not connected to the person who made the original decision, it's considered a fair local appeal. The review needs to take into account anything that was documented, recorded about that decision. What the rule has since changed is we used to have this ability to say, we're only going to look at to the individual. We're only going to look at your information up to the time we made the decision, because that's all we had. The rule has since changed to say if new information has come about since then, you do need to include that, because if something's changed, that would have affected the decision in the first place. That really should be incorporated into the review at that point in time. And the option and the ability of that individual to share information needs to be part of the process. So part of what I've done in local appeals is when I inform somebody of, hey, we got your appeal, this is when the local meeting's going to happen, this is how it's going to happen, do you want to have a voice in it, do you want us just to review the materials, how do you want it to work? I do ask them, is there any information that you have that you want us to look at? And if they provide that, that has to be involved in the review itself as well. Which leads right to the next point about the opportunity for them to bring information. They have the right to review anything, records that were related to the appeal. And once the local review is done, they need to get that resolution letter, that outcome in writing. There is a state form template with that resolution letter that anybody can use. And that outcome letter basically needs to give them their rights to the next level of appeal, which would be the state fair hearing. The important thing that I want to note in the forms, and I'll note that later too, is it's super important when you give a notice to somebody about a negative action about their services, when you give them an adverse benefit determination notice, that the only thing that you send with that for them is the second appeal request form, if it applies to that decision. It might not. And the form to request a local appeal. The only time you would give them the Medicaid fair hearing form, or even give information about the Medicaid fair hearing process, is if they have a right to go straight to a Medicaid fair hearing. And the only time that that's allowable is essentially if we as a system have messed up. If we either didn't give appeal notice at all, or didn't follow the local appeal process, they actually have the right to go right to a Medicaid fair hearing if we as the system who's supposed to give them their rights doesn't follow the system. But outside of that, what we found is historically there were times when that person was given all the forms, all the things that can be possible in an appeal, and they were sending requests for hearing before they even had a local level appeal. And it created a lot of undue burden in the hearing system. It kind of affected the docket so that people who really needed and were at the point of having a hearing had to maybe wait longer because of what was going on with hearing requests that actually didn't meet the definition of a hearing request. So we're asking that when you give notice to only provide the local appeal form, and then the hearing form options you would give when you send out the outcome of the local appeal. That would be the point in time when you would give that out. And for non-Medicaid folks, the process is, again, somewhat similar. There's just a lot less reasons why they have a local appeal. And they're given a written notice as well, and their right to access the state contracts folks, and that they only have 10 days to do that. So let me talk a little bit about the local appeal process in the time of COVID. So what the regulations say is they're very clear about what has to happen in the process for local appeals, about who is there, what information you review, and what information you send out about your decision. What it's relatively silent on is how those meetings actually happen. So you can have, there's a wide variety about how those local appeal process happens. Kind of the,
when are these for? They're not
sorry, I
like,
think somebody's on,
they're not the same day.
I'm gonna politely mute him. Thank you. So that can be anything from having an in-person meeting, which now would be through Zoom or some other secure format, where the internal staff and the individual and whoever they want to bring come together and have a conversation face-to-face, remotely face-to-face. That can be done over the phone. That can be done as a local review, and any other way to bring that individual's feedback can be brought in, whether they want to send information or they want to call. So there's a lot of variation with how those occur. Some providers basically do the review and allow the individual to have some kind of say, but not actually be present in the review. Some actually allow them to be present in the review. I personally have always operated under the spirit of transparency and open dialogue and relationship. So when I was the Fair Hearings Officer and in the CMHs I worked for, I would have those be in person or transparent as much as possible. But that's just a value-based system, value-based judgment. That's really up to the individual provider about how they want to work that out. And certainly in the time of where we've been at in the last year, the ability to be that transparent and open for dialogue has had some challenges. So it really is up to your discretion, as long as you're following the information that goes out, how it goes out, and how the review is done. There's some variances in how that can happen. So with that, I'm going to stop and see if there's any questions about the local appeal process. No? Okay. So the state level appeal process, the one part that I want to note on this is, and it's at the end of your slides, but once an appeal gets to a state level hearing, especially a Medicaid fair hearing, that's where your friendly Fair Hearings Officer comes into play and manages those levels of appeals. So I'll talk about that in a second. So like I said before, there's two types of state level appeals, one for Medicaid, one for folks who don't have Medicaid. If you have Medicaid and the local appeal decision was upheld and you don't like the outcome of that, you can take that to a Medicaid fair hearing before an administrative law judge. That administrative law judge hears each party present their case and make a decision. They have been doing in-person hearings over Zoom. So you can ask for a hearing either, you can specifically ask for a hearing in person. If you don't ask for a hearing in person, by default, your hearing is going to be over the phone. It's going to be a phone conference. But right now, the administrative law judges are doing a lot of things on Zoom. And there used to be, with the phone conference, they used to require the individual to come to the provider site to do that phone conference. So like for example, at Monroe CMH, if we made the decision, the person had to come to Monroe CMH to actually be present for the phone hearing, and we were all in the room together. With COVID-19, they've obviously changed that, so you can call in, you're calling in separate lines from any location for the phone conference as well. And when pre-COVID, the judge used to come right to the CMH or the county with a hearing where the decision was made to do the in-person hearing. When the COVID situation is over with, they will come back into those in-person hearings and be present. The judge for SUD hearings, the judge has been coming to the PIHP site for those. So all of the SUD related hearings for Medicaid have been happening at the PHP site. So they would happen for us at the Zeeb Road site. If that becomes like an undue burden, both for the consumer and or the provider who has to be present, just because we have a pretty big region, we can talk to the judge about that and see if there's, see if they'll accept a different location. So just so you know that there's options for that the Fair Hearings Officer can advocate for. And like I said, that consumer or their authorized hearing rep has to ask specifically for an in-person hearing, or they won't get one. They'll get a phone hearing. The Office of Administrative Hearings and Rules, we call them MORE, manages the hearings and sets the schedule. They have a whole docket for when the hearing would take place. All parties involved will get in writing when a hearing has been requested. So there's a notice of, hey, we got this request for a hearing. And then the second notice will occur when they've set the date, the time, and the place for the hearing. And those will happen in writing, and all parties receive notice of that. The consumer, their authorized hearing representative, if they have one, the provider, and the PIHP. The judge sends a decision and order in writing, both to the consumer and the other party involved. A judge's decision in these Medicaid Fair Hearings is legally binding to both parties. So if the judge orders us as a system, as a provider, to do something, and we don't do that, that individual can actually take us to circuit court. And as I said before, as with all types of appeals, administrative hearing reps can be present and represent their case, but the consumer or the guardian can also be involved as well. And for non-Medicaid hearings, like I said before, the state contract staff reviews that. They have 2 days to get that done. Well, they have 2 days to look at it, and then they have 15 days to answer it. The decisions from the contracts, folks, is not binding. It's not legally binding. There's no action that somebody can take in circuit court or any other court if they're not happy with the outcome of a non-Medicaid state level review. I have seen our state contract change as some as a result of the appeals, where they've changed some of the requirements as learning from some of these things. But legally, there's nothing binding in a court. And then the role of a fair hearings officer, and I probably should have switched these sides a little bit, but there are fair hearings officers across our region that are trained to represent and manage cases at the state level, at the Medicaid Fair Hearings level. So they're the ones who pull all the information together, bring folks together who might need to testify about what's going on, coordinate the hearing with the individual who requested it, or the authorized hearing rep, and puts the case together and presents that before the judge. For Washtenaw and Monroe SUD providers, I'm actually the fair hearings officer for that level. And the only reason that I say that's important now is there's been times when we got a hearing and I contacted the SUD provider And their response was, you know, with 42 CFR, I can't give you information. I can't be involved in this. And my response to that is, yes, you can, and actually you're contractually held to. So anytime you hear from me as a fair hearings officer that there's been a case, you are allowed to share that information. You are allowed to provide the records, and you would be in a position to provide information and probably testify. If you're ever involved in a hearing, you are going to know way ahead of time. You're going to have all the information available to you. I lay out all the questions I'm going to ask. We walk through how we're going to answer those questions. You walk into that hearing knowing exactly what's going to be addressed and how you're going to be asked to respond to it. There's not going to be any surprises in that respect. There's a lot of preparation that goes into that. But just to be clear in terms of contact, it is very much allowable to share that information with a fair hearings officer. So we do all the preparation. We help folks who need to testify about that. We also are available for training and consultation to folks. And there's a statewide group of us nerds who are really into all this Medicaid law stuff that gets together and talks about policy and changes. And we do have a really good, although objective and healthy boundary relationship with the Michigan Office of Administrative Hearing and Rules. We work together with them, in conjunction with them. We give feedback back and forth about what's working about this hearing system, what's not working, some of the trends that are going on with decisions and orders with judges. And your fair hearings officer would also be the person to, if the judge's order and decision seems appealable, if the way they approach it or the decision that they make is something that we could appeal, that fair hearings officer would be would take over the responsibility of pursuing that appeal if we agree that we want to take that step. So where to go for help and more information? So like I said, I am the fair hearings officer for SUD services for Washington and Monroe counties. Katie Snay is the fair hearings officer for Washington CMH and Livingston CMH and SUD decisions with Livingston, because Livingston has a separate SUD system. Jacqueline Brady is the fair hearings officer for Lenawee CMH. She also would manage SUD related hearings for Lenawee, as they are also their own core provider. Megan Chanella is the fair hearings officer for Monroe CMH only. And then, like I said, I manage the SUD hearings for Washington and Monroe counties. So with that, I'm going to stop. No, I'm not going to stop sharing. I'm going to end the show real quick. And let me just jump to the forms. The challenge for giving notice with the SUD provider system, which I fully recognize, is there's not a shared electronic health record system where you can just go in and use all the same forms. We do have that advantage in the CMH system because we are all under the same EHR, that we all use the same forms for the CMH system. So the forms themselves that the state has required are here, and the link to them is in your PowerPoint as well. You can download these. You can, they come in Adobe. You can convert them into Word. If for any reason you need these forms and you don't have the ability to do Word conversion, shoot me an email and I'd be happy to convert them for you and send them back. Probably as I'm talking, we probably should just do that and make them available somewhere, just to skip that whole request process. So we'll do that. So there's the state requirement forms. Have a form for notice of adverse benefit determination, which is a general denial. They have forms for notice of your right to notice that we've received your appeal or your grievance. So there's when somebody requests an appeal, there's a form that gets sent out to say, we received it. This is what's going to happen about it. This is when it will occur. And then when the local appeal is completed, there's two forms for this. One, if the appeal has been approved, which is basically what you disagreed with, we agree, we're reversing the original decision. Or if it was denied, which basically is if we agree that we made the right decision and we're upholding the original decision, that would be the form that would be sent out. And those four forms are the only ones available. We do have, like I said before, denial letters for the decisions that they only have a right to file a grievance on, and the second opinion forms. And I think what we'll talk about, Nicole, is the most accessible way to make those available. We historically, I've noticed, haven't had those forms on our website. And I think some of the concern was, when they change, do we make sure we're giving people the right forms, all that. But we'll revisit that. And what we will do initially is send these forms out in Word document and make them available to you for everybody who's attended. And then we'll communicate with you down the road about how we've opened up access to that, so you don't have to necessarily contact me and request them specifically.
I do have a question. Are we allowed to create this in our EMR? And this person who's asking did submit a copy to Midstate for approval too.
Yes. I'm going to give my my Reader's Digest version of my opinion on it. So part of the challenge with these forms that all the fair hearings officers got together and take a look at is there's some aspects of this that we felt were missing from the forms we originally created. We are going along with, we are going to comply with the state contract. The state contract says use these forms. We're interested in what the federal audit coming up with the managed care rules is going to say about those, so they may change. But I would say anything that the state has mandated in this template, you absolutely can put on your electronic health record. They're available for that. When you receive the forms that we've created, if you're interested in using those, you absolutely have free reign to use them electronically, upload them in your system, whatever way that you want to. If you want to use your own forms, I would just make sure you're following the requirements about what needs to be in those forms. But that's a very long way of saying, yes, you can absolutely take these forms and upload them in your electronic health record.
It's the only question so far.
Okay. Well, thank you everybody very much for your time and your attention, and feel free again to contact me. And I don't think I gave you my contact number, so I'm going to put that in the chat.
Does anybody else have any questions for CJ? You can raise your hand, I think.
I was typing one, but if I could just say it, I'm looking for a list of recipient rights officers for each the PIHPs, and I'm having a difficult time getting updated ones or just in general one. And I am the rights officer for Holy Cross.
So I'm sorry. Are you wanting the recipient rights officers in the CMH system, their names?
Yes.
Okay. I can definitely get that to you. I can also tell you that if you have any questions about that system or those staff, I don't know if you're familiar with Shane Ray, but Shane Ray is the director of the rights system at the CMH level. He can answer anything for you as well.
I was actually, I'm sorry, not just the mental health, but SUD too.
Oh, okay. Well, for SUD rights, each provider has their own SUD staff identified, and I don't know. I mean, we have maintained a list of that in our contract system, but I can't say that we've updated it. I do know that and maybe Nicole and Joellen, you might want to speak to that level of that list, because every provider has their own SUD rights person, and that changes. That can
A lot.
change.
I think that's why the list is so hard, because I even at the rights conference in the summer, I'm like, please, somebody.
Yeah, what I can say, I'll come back to Shane Ray again. Shane Ray is the contact for the second level of rights appeals.
Okay.
So any SUD rights review that goes to that second appeal level, Shane Ray is the person who manages that. So he might know some of the local SUD rep. I can ask him if he has any kind of list. I just want to be transparent that he might not.
And and that wouldn't surprise me. And they say it because it changes so frequently. Even a list that they put out there isn't up to date. So, okay. Well, I thought I'd ask one more time. Thank you.
Yeah. If we come up with some miraculous way of tracking that, I'll let you know.
Perfect. Thanks a lot.
Maybe I missed this along the way, but you're going to be providing us with the PowerPoint?
Yeah.
Okay.
The PowerPoint and any of the forms that we created that aren't those state templates that I shared the link to.
All right. Thank you.
Any other questions for CJ? Okay, I think you did a fantastic and so thorough job. That was really helpful. Thanks, CJ.
Thank you.
I see people clapping. So.
Aw, thank you.
There's that emoji you can use too. I think you can click on the little clapping thing too if you want. And we did record this too, so we can, there you go, Diana figured out how to do the clapping emoji, if you want to look at Diana. We did record this, so we'll figure out how to make that available for people if we need to do that too. Okay, so I'm just going to take a couple more minutes of your time.